Very warm welcome. This is the fourth module of week 5 of the course Entrepreneurship and IP Strategy, titled Copyright Infringement. This is one of the very important section of Copyright Act 1957. Chapter 11, section 51 to 53 of Copyright Act 1957 provides details about what is infringement, what are exceptions to infringement, and in further sections of the Act, various remedies are suggested if there is an infringement. Section 52 is a very important and unique when we consider Indian Copyright Act. This section lists various acts which cannot be considered as a copyright infringement and provides details about what can be a fair use. With the logic, you can understand the reasoning behind the section easily. Why this section is included in the Act and what benefits users are getting because of this section. It is a very interesting section and it is a most long section we can say in the Act. We will go in the details of that in a few minutes. Before we start, I wish you to appreciate the creators of the Act who have drafted this section, that is a section 52. We will try to go in details, but we will share the various acts in the reading material. As this section is very long, what we have done, we have hosted the reading material, that is a section 52 in the folder of reading material. So, you can go in details of that section 52 there. Now, there are almost 25 plus acts which are included that are listed as acts which cannot be considered as an infringement as per Copyright Act. You can understand it easily by reading this section 52, that which are these acts, and they have given the nice explanation about that particular acts, and with that examples you can understand, okay, this is the act which is not be the infringement of a copyright. But we will see a glimpses of that when we will go in the details further. We can see the empathy and visionary approach of a lawmaker to think as a common man and appreciate possible issues which may arise due to copyright, because copyright as such, when we are considering the IP Acts, in that IP Act we can say that Copyright Act, there are so many grey areas are there, but still if you see this section 52, you can appreciate what efforts they have put and what a visionary outlook they have kept while drafting the section, that okay, possibly this situation will be there and the person will be in confusion whether I am infringing the particular copyright act, copyright of somebody or not. So, that confusion will be there. So, to avoid that, they have listed in detail that particular acts and they have given the explanation. Now, this section we can say that is a very thoughtful and elaborative section of the Copyright Act. It is just like a section 3 of Indian Patent Act, where I am just giving you the analogy, because section 3 of a Patent Act is one of the what we can say important sections where we know that inventions which are not patentable, that are covered. Now, here in the Copyright Act, this section, that is section 52, what they have covered? Okay, these are the acts which by doing that particular activity you are not infringing the copyright. So, you can understand that I am just giving you the analogy between this patent law and a copyright law, that there it is a section 3 and here it is a section 52. Now, after going through this section 52, you will also appreciate a Copyright Act of India, because this is a unique to Indian Copyright Act, as how the attempt is made to strike out a balance between the right of an author and a welfare of a society. In short, a human rights angle whatever is there, that is perfectly balanced by such section. Other second point, I wish you to think carefully and provide your analysis of section 52. So, this point of discussion is as follow. Why I am saying that you provide that carefully you should go through this section 52, and application of section 52 should be very careful. Means you once you go through that section 52, that list, you will know the permitted usage now. Now, however, it is important and please provide attention here what I am saying, that okay, section 52 is giving you idea that okay, these are the acts which are not what we can say that will not go into the, okay, you are not infringing. These are the acts which will say that these are exceptions to the infringement. It is like a fair use, but it must be applied with a judicial understanding of the facts and taking into consideration, as mentioned earlier, rights of a author too. Means we have to keep or strike a balance between, okay, the author has put effort, it is his or her creativity, and okay, because of particular action in particular way, you are not infringing that particular thing. But whatever that limitations are there or the guidelines are there, we have to follow that guidelines very carefully, that up to what limit that use is permitted. After that particular limit is crossed, obviously you are infringing the copyright. So, you have to read carefully section 52 and you have to strike a balance and you have to give due weightage to the efforts which are put by the author also. So, that way we have to be very careful when we are talking about a section 52. So, we can say that there is a thin line between fair use and a copyright, and it must be understood before anyone explore the copyright material or the creations, because it should not happen that fair use crosses the boundary and then it will affect the rights of a author. Having said that, and with this background, now we will go into the details of a infringement. Copyright owner's right, as we have seen in earlier modules, are here few copyright, whatever the copyright rights are there, you know, to produce a work, to create a derivative work based upon it, to distribute copies of work of the public, to publicly display or perform the work. So, these are the, what we can say, 4 important, what we can say, the rights which are given by the copyright. What are they? To reproduce or copy a work, to create derivative works, that is adaptation mostly we call, to distribute copies of the work in the public, to publicly display or perform the work. For example, if I want to give example, I can say that if you create a any author creates a work, copyrighted work. So, for example, book is there or any CD is there. So, he can reproduce a work, obviously. He can create derivative works based upon that. So, for example, book can be converted into drama, book can be converted to movie. There are so many examples of books which are converted into the movie, that examples are already there. Then distribution copies of a work in a public. So, in the public, if you want that, okay, I am the owner, I can distribute freely also, or I can expect a very minimum what we can say return on that particular thing, or I can charge, or I will just what we can say, it price will be dependent on, as I am an author, I can determine what price will be there. So, based on whatever the model is there, but I as a copyright owner can distribute copies of the work to the public, and then I can publicly display or perform my work. Means nobody can what we can say, nobody will stop me by doing if I want to display that publicly in the exhibitions, or if I decide, okay, I will take one hall and I will exhibit my photography. If anybody is doing the photography, he might having that he can book the hall and he can display his photographs and he can invite people, and public, in that way he can do the public display. So, anything, if you are a copyright owner, you can do particular things, and these are the things. Now, what do you understand by unauthorized use here, or where infringement comes? That unauthorized use, that okay, these are the rights of a copyright owner, but if I am not a owner of that copyright and I unauthorized use that particular thing, then it will attract a infringement case, or it will be like I have infringed copyright of somebody else. So, for example, if I want to give an example, that suppose some person has clicked a photograph. So, person who clicks a photograph, we have already seen that these are the author, he or she will be the author of that photograph. Now, without permission of that author, if I take photograph and if I say that okay, this is a photograph and I will pose myself as I have clicked that particular photograph and I will use it in the maybe some book, or if I want to create some what we can say PowerPoint presentation, and I will take that photograph and I will put in the PowerPoint presentation, and if that will have a commercial angle, then obviously it will attract a legal action on me, because I have infringed the right of a copyright owner. or somebody has created a book, and if I take a 2 pages as is, and if I will copy that particular pages and I will write an article, say 10 pages article, and in that 2 pages I have already copied from somebody else books, obviously it is a what we can say the infringement case. So, here what the thing is that I am not a owner, rightful owner, but still I am using that particular thing and I am posing myself as I am owner of that particular work, and that attracts a legal action. Now, moving further, if you see section 51 of the Copyright Act, it will specify that when a copyright is infringed. So, that section 51 is clearly giving you the guidelines that okay, these are the acts, and if you do that particular thing, you are infringing somebody else's copyright. And then section 52 comes and it says that okay, these are the acts, and if you do these acts, you are not infringing the copyright. So, these are given like a section 51 and section 52. Okay. Now, moving further, what are the elements of infringement? So, elements are like work was the original creation of the author, second, defendant copied the work of the author, and then the third, substantial similarity between the works of the author and the defendant. So, here these are the 3 important points, how the infringement is determined, or when the case will go into the court of law or in the copyright office, how it will be determined. You have to understand first that okay, whether that work is the original creation of an author, that is the first thing. Second thing is like defendant copied the work of the author. If you want to take an example, I will take a simple example as a research paper. Suppose you are a researcher and you have written a research article in a journal. Now, what you have done? While writing that particular paper, that manuscript, suppose X has written that particular thing, I have completely taken it, that particular thing, maybe paragraph I have taken and I have put as is in my journal, in my manuscript. I have not given attribution also, and I have taken a para, I have not taken a single line, but I have taken that complete para as is, no attribution, no what we can say acknowledgement. I have not given in the reference that okay, this is the original author, I have not said anything. And now manuscript I have submitted to journal. So, what the thing I have done? I have posed myself as I am the original writer for that particular paragraph. So, defendant copied the work of the author. Somebody is there who has done it, he is the author. I am the one who have copied that particular thing, that is I am a defendant, I have copied that thing, and there should be a substantial similarity between the works of the author and the defendant. Now, I will give you a little more explanation here. Now, sometimes what happens, especially in this research paper, what people do? They will use thesaurus or they will use that synonyms, and they will say that okay, copyright is for expression, we all know that. So, in that expression, I will change the words. Only changing the word, whether I am completely what we can say, I am just taking that paragraph as is and I am just replacing that words in that particular paragraph. Now, if I am replacing that particular word, obviously although I am replacing that, still I am doing a copyright infringement, because it is not my original creation. I have not created, that thought process is not mine. I have just copy paste, give the synonyms so that I can just say that okay, I should not take a line as is. Instead of that, I will just make a minor changes, passive voice to active voice or active voice to passive voice. If it is like a competitive thing, I will say something like the very synonym for that particular word I will use, and then I will complete the paragraph. Now, if you do something like that, you are doing the copyright infringement. So, this is a one example. Now, the another example is like in the film industry and publishing industry. This is very, very important. Means when we talk about a copyright, publishing industry and film industry is these are the two important industry where copyright play a major role. And we see many cases that okay, this movie came and somebody is saying that oh, this is my creation, this is my book and this now adapted as a movie, but credit is not given, or this is a TV serial, this is my creation without my permission, this is like adapted as a drama or a TV serial, something like that. All this kind of things probably you have heard in the newspaper. So, this is something like a original creator is there, defendant had copied it, and there is a substantial similarity, and judges will determine that expert will determine that okay, what is that substantial similarity is there, and if that substantial similarity is there, definitely it will be a case of infringement, and obviously you have to face civil action or a criminal action, whatever initiated by the plaintiff or a author. Okay. So, there are two types of infringement, as a primary infringement and a secondary infringement. So, secondary infringement is like it refers to the infringement of a copyright work without actual copying it, and this is very important. Now, why I am giving you, as an entrepreneur, probably you may not copyright, you may not go and do the infringement and all that thing, but you should able to judge when your creation, if suppose you are working in a publishing industry, or if you are working in the film industry, or maybe you are working in a very hardcore technology field, but your this brochures are there, customer list is there, some data is there, or manuals are there, right, or your website is there. So, all this is a copyright material. So, when you are creating all this material, what kind of secondary infringement? Primary infringement is there, secondary infringement there. One infringement is like a direct copy paste, direct that particular thing is taken and it is somebody has posed himself or herself as a, she is a or he is a creator of that particular thing. Now, second kind of secondary infringement is another concept. Now, what that concept is like? Providing a place for copyright infringement. You may be ignorant about that thing, you may not be knowing that this particular fellow is selling something which is a copyrighted thing, and you are allowing him in the premises you are owning. Now, if you do it ignorantly also, probably you will attract a legal action against you, although you are not knowing that this is a what we can say what we can say either plagiarized material, or it is a copyright infringement is there, or a selling infringing copies, that is also what we can say copyright infringement, or distributing the infringing copies, and then the fourth one is importing infringing copies. Suppose you know that this fellow is like this person is like owning that particular thing, you have not done any activity in India for creating that book or that movie, but what you have done, you have just imported from other countries. So, for example, the movie came from Dubai to India, or movie came from China to India, but it is created in India by some author and it is a lawful owner of that, but you may probably are not aware about that particular thing and you are bringing that copy. And we know that this is very major issue when we are talking about movies like pirated movies and all. So, the thing is that probably you may not be knowing, most of the time you know that okay, who is the owner, and many times you also know that okay, I should not use that particular what we can say movie, or I should not display it on a public platform, but still the things are happening. So, those who are contributing in this activity, they are also what we can say legally responsible for this infringement, and they attract the what we can say the legal action. And therefore, you have to just remember that if you are hosting something which is not a what is a copyright of somebody else, and till if you are hosting on your website, then it is the infringement by you, as you are hosting that website is your website. So, we have to be very careful when we are hosting material, and therefore, you see in many of the cases you see the notice that now you will be going into the that hyperlinking policy is also there, and they will give you the clear what we can say disclaimer kind of thing or a caution kind of thing that we are taking you into the different website. So, that way they are clarifying that okay, whatever data you will get, that is not from our website, that website you are now visiting the another website. So, that caution is taken here. So, we have to take a precaution. So, as an entrepreneur, probably you will create a website. Now, when you will create a website is a very good what we can say the IP which is involved here is a copyright mainly. Now, when you that look, that feel of that website and the content which are hosting on that website, all must be your own content. If you are hosting content of somebody else, we have to give the attribution, or the another thing is that if you are hosting some links, you should clearly give the link, and then that link should open into the window, another window, and that window should be the official window of that particular owner of that particular content. So, that caution we have to take. So, that is a one caution when we are hosting the website. And then the material wise, I have already informed you that your premises you should give to the, if you are allowing somebody else to use your premises, you should know that the business, the activities which are going on, these are the lawful activities, and there are no any, what we can say, the infringing activity is not happening. Now, moving further, we will understand what can be the infringement, what cannot be infringement. Section 52 we are talking about. So, it is like a, the list is there like a research or a private study, judicial proceedings, short passages, private playing, reproduction in current issue in news, making of a drawing of a architecture work or a sculpture in a public. Okay. So, we here only few examples we have given, but I have already told you there are 25 plus acts which are given in the section 52. So, you can go in the details, but I will give you a little bit glimpses of that here. So, for example, research, academic research, when we are talking, and this is a very much question when education institute or a research organizations comes. As per Indian copyright law, if you are doing a research in public institutes and it is only with the purpose of for a research without any what we can say commercial approach, it is, there is no any commercial intention. So, if that is the case, then in that case you can use a copyrighted material, and that is considered as a fair use. And you know that in the education institute, fair use is very much important, and we are reading lot of material because of that particular fair use, what we can say the doctrine or fair use concept. Okay. Then the judicial proceedings are there. If you read a high court judgments or Supreme Court judgments, wonderfully written judgments are there, but we have to remember that these are like open to public. You can see that and you can quote that particular judicial proceedings. Obviously, you have to give the attribution. Then in some cases short passages are allowed. Obviously, you have to give the attribution here. Then private playing. For example, what do you understand by private playing or some activity like that? So, suppose there is a one function in the society, and for that you have used any movie song, and based on that movie song, some drama or some what we can say dance or some activity is a plan in that society. Now, whether in that case society is infringing any copyright of that particular performers or the producer or whosoever the author is. So, the answer is that if it is a private playing and if there is no any commercial intention, obviously in society it is a recreational activity, and to just recreation for the fun activity without any commercial angle, you are doing that particular thing, and as it is a private playing, obviously it will not attract any copyright infringement. So, that understanding should be, so we need not to worry that okay, if in my in some marriage wedding wedding activity or in the any function or family function, if songs are used and all as a what we can say as a part of that festive mood or something like that, obviously that will not attract a copyright infringement. But if you are having a DJ and you are that is some commercial activity, obviously at that time if you are playing some 100 songs in that DJ, you have to take a license from the licensing society. So, we have to understand that difference. Okay. Then reproduction in current issue in the news. Now, this is one of the very prominent subject actually, means facts, they are not changing, whatever facts are there, news are there, that are not changing, and that facts as is, if you have taken by any of the what we can say the news channel or a newspaper, then obviously what will happen, it is accepted, there is no issue. Now, but as this point came, I would just like to give you the current scenario I am giving you, that the newspaper, and in that newspaper the debate is going on that why that newspaper, that whatever the news are there in that newspaper, if they are put into the social media, that is nothing but a copyright infringement. That debate is going on. We will not go in details of that. That is this is a very what we can say serious issue actually, but I am just giving you the glimpse. I am just giving you the idea about that particular thing. Okay. Now, making a drawing of architecture work or a sculpture in a public. So, if it is a creational activity and as just some exhibition is going on in the school and some student is like a very good in what we can say in drawing and all, probably he can create the some drawings or some diagrams or some architectural work is there, he can create the draw that particular architectural work. Obviously, it will not attract the copyright infringement. So, there are so many, we will go into the details, you can go into the details when you will go to the reading material. Okay. Now, moving further, here we would like you to share one opinion of Professor Lawrence on the photocopying case. Now, this is a Delhi University photocopy case, very popular case. University of Oxford was and others versus Rameshwari photocopy. Now, here what happened, this case was of August 2012. Oxford, Cambridge and Taylor Francis were the plaintiff, Rameshwari Photocopy Services and the Delhi University is a defendant. Now, claim was the course packs that are distributed is the violation of a copyright and damages claimed were 60 lakhs. Society of Promotion of Education Access and Knowledge and Association of Students for Equitable Access to Knowledge, both were involved in this case. Now, the judgment which is given by Justice Endlaw, it is a 94-page decision. He dismissed the suit of the plaintiff, held that the educational exception under section 52(1) of the Copyright Act is broad enough to cover the acts of photocopying and the creation of a course pack by Delhi University. Now, you can go in the details of the case further because this is a very prominent case and you can see lot of reading material over that particular case. I have given you the little bit idea about that particular thing and you can just judge that section 52 fair use kind of thing and the actual the copyright. Here that particular issue is taken into consideration in this case, like a Oxford, Cambridge books are created by them and here a photocopy center, they are making a photocopy and distributed in the notes are distributed among the students. So, whether that booksellers, that publishing company, they are not losing their revenue because they are not getting returns. Suppose 50 students are using that particular thing, whether they are not getting returns, you just think over that particular thing and you can see the opinion of Professor Lawrence here. Now, Professor Lawrence, I can give you the little bit idea about Creative Commons here. Creative Commons is like a copyright is like I have already told you that it is a grey area, but there are certain movements like a free open source copyrighted material means open source material is available. So, it is like a something copyright which is a very stringent and open source like a freely available. So, there are so many examples of a freely available content is available online and there are so many websites which are providing the content freely. And Creative Commons is one of the what we can say activity which is initiated on India chapter. When we say Professor Lawrence is like a actively involved in that India chapter of a Creative Commons. Okay, so we can just see that video.
Welcome to the Macmillan Report. I'm Marilyn Wilkshire, host, and our guest is Lawrence Liang, a legal researcher and lawyer based in Bangalore, India, known for his legal campaigns on issues of public concern. He is here at Yale as the Rice Visiting Fellow in the South Asian Studies Council at the Macmillan Center. His key areas of interest are law, popular culture, and piracy. Professor Liang has been working closely with the Sarai program at the Center for the Study of Developing Societies in Delhi on a joint research project on intellectual property. Today we talk with him about the recent ruling on the Delhi University photocopy case. Welcome, Professor Liang.
Thanks, Marilyn. Pleasure to be here.
So let's begin with an overview of the photocopy case. Tell us about it.
Well, what happened was around 4 years ago, some of the leading academic publishers, Oxford, Cambridge, Francis and Taylor, filed a copyright infringement case against a small photocopying shop at Delhi University, along with Delhi University. And this was about course packs.
Okay, so You can watch this video and you can see what are the what is the opinion. Now, moving further, I have just mentioned you about Professor Lawrence. Now, you just see the licenses of Creative Commons. So, these are the licenses of a 6 major licenses are there. You can just go through in details. It's available online. Okay, just I thought if we are talking about copyright, there is a open source content available also. Okay, and open source software movement, it's a big movement. Probably most of the IT people are much aware about that thing. Now, we will move further and we will see just one more case. It is a Press Trust of India Limited versus Navbharat Press, that is a case. Now, you know very well that PTI is there. Now, PTI provides that they are giving you the news, like, so Plaintiff is a premier news agency, PTI is a premier news agency. Defendant runs English and Hindi Delhi means that newspaper, Central Chronicle and Navbharat. Now, plaintiff supplies news only to subscribers. Without authorization, defendant published news articles of a plaintiff. Okay. Now, defendant did not appear in the case when the case was in the court law, and obviously, it given the permanent injunction and a punitive damages of 5 lakh to that Navbharat, the Navbharat owner, that is a defendant, they have been charged with that particular 5 lakhs of damages. Okay. There is another case, like moving further, we can see this is a very important case and it is a very film industry case. It is an old case, you can see. It is a Crazy 4 tune, you probably well aware about that thing, that Ram Sampath is a creator of that particular thing. It is a very interesting case. I will give you the glimpses of that case and then we can watch that video. So, here Ram Sampath, at that time he was like a 32-year-old music composer. Now, what he has done, very interesting scenario it is, Friday generally movie releases and in that week only, in the starting of that week, obviously the distribution of that film, everything is what we can say ready, and film was like about to release. Now, what the thing happened, he dragged director Rakesh Roshan, his musician brother, that is Rajesh Roshan, and their film company, Filmcraft Productions Private Limited. Okay. Then along with that Sony Ericsson and then the Super Cassettes Industries also. And then what he has done, Ali, that they have copied the music for Crazy 4. Now, what Mr. Ram Sampath claimed that the 4 tracks, the title track, the Break Free and their remix versions have been lifted, have been copied directly from the thumb is here. That is a jingle, a small 30-second kind of, so it is a very small jingle, and he had created for a Sony Ericsson mobile in 2007. Now, in this case, now you can see the scenario that movies are about to release, everything is ready, and in that week only this case goes into Bombay High Court, and then what judge says. Now, if you see the judge opinion here, judge clearly said that Bombay High Court, now what they have said, that you can just I quote, to my untrained ear the music appeared to be similar, that Justice Karnik, who listened to both Sampath's work for a Sony Ericsson cell phone and the 2 songs composed by Rajesh Roshan for the film, he said that particular thing, and obviously the court stopped the sale of the audio CDs and cassettes, and now in this case actually Ram Sampath, he claimed damages of 2 crores against Roshans and he won the case. So, this is a very popular case in the film industry. Now, you can watch the tune here.
Vasant is here.
Okay. So, you can watch this tune later if you are interested. Okay. So, now moving further, here is another last case we are citing here, Da Vinci Code case is there. The authors of the Holy Blood and the Holy Grail, they claim that Dan Brown copied substantial portion of the book and central theme, although High Court of London refused to grant relief to the authors since substantial portions were not copied, although Dan Brown may have relied exclusively on the said book. He was relied on that book, but we cannot say that he has done the infringement, that is a judgment given by the court. Okay. Now, what are the remedies available for the infringement if infringement happened? Now, what happened that as an entrepreneur, Which are the areas? If you are in a film industry, publishing industry, you are majorly working in a copyright domain considering IP part. If you are in a technology domain, probably your interface with the copyright is limited, as I have told you, that websites or that manuals, that customer list, all that kind of thing will be there. By any chance, if somebody do the infringement, you can see on the screen there are remedies. 3 kinds of remedies are there: criminal remedies there, civil remedies there, and administrative remedies there. And obviously, you can see the details there on the slide. We will not go in the details of that. You can just read and you can understand what exactly the remedies available are there. Now, as you have seen now that okay, this is like a copyright thing, infringement is there. You have already learned about the subject matter, how to do copyright registration, that also you have seen in the earlier modules. Now, how as a entrepreneur you will take care about a copyright, as a businessman how you will go about that thing. If you are a website owner, please you will make sure that okay, my website will not copy content without checking the policies of the from where I am getting that content. I will check the policies and see that if any notice is there or what particular what we can say cautions that particular site has given when I am taking a content. Now, there are various as I have told you, Creative Commons is that kind of licenses are there. So much content is available freely, sufficient content is available freely, and probably you can use that content. Videos are available, images are available, reading material is available, that is a one thing. Next is that every IP, mostly every IP, because one IP is there which is a continuous, that life is infinite. So, mostly this, in case of a copyright, I can say that time period or a life of copyright is unlimited. So, for example, now Ravindra, what we can say, the whatever the literature available, that Ravindra literature is freely available now. So, you can use it for drama, cinema, nobody will stop you. So, here the thing is that such kind of materials are also available of which copyright is already expired, that lifetime is already over and that is now in the public domain. So, that kind of publicly available material is already there. So, if anybody want to use the material, you can use it obviously as you will give the attribution and there will be no issue in adapting the work also. So, that kind of thing is there. Now, if somebody does the infringement, your copyright is copyrighted material used, I have already given you the remedies. So, you can initiate any of the action. Obviously, with a if criminal case is there, if you want to file, police are also very well trained and they can take immediate action if there is any copyright infringement. So, you can approach a police station also. So, that things are available. Now, considering the what we can say databases are there or some digital libraries are there, right. So, Wikipedia is another, these are the examples. So, some libraries which are online available are completely free. Some libraries are like they are charging some subscription and all that thing, facilities are there and we can use that particular thing. Okay. So, the caution is like do due diligence and then only you use the material. If somebody copies your material, then you can take a that remedies are there, you can use that particular remedies and take action. And one more example that I can give you, that is a Facebook example. If you try to give a music, probably Facebook gives you the notice that this is probably a copyright of somebody else and kindly check that particular thing, that kind of notice they will give you. So, that awareness is already there and such kind of disclaimers or cautions or notices are already provided. If you see the sites, policies are there, in the policy details are already given. So, that kind of awareness is already there. Okay. So, I guess this is good enough for you to understand that copyright infringement as an entrepreneurial angle, that is good enough that okay, this kind of activity is infringement, section 52, this kind of activity is not a infringement, and then the details, a few details are there, and in the reading material we have already given you the that section 52 in a detail. Okay. So, with this we come to the end of this session. See you in the next session. Thank you.